number 4, Arrowhead Capital Finance versus Cheyne Specialty Finance. Counsel?
May it please the court, my name is Barry Golden. I am counsel for the appellant plaintiff, Arrowhead Capital Finance Limited. I'd like to reserve 4 minutes if I could.
Did you say 4, counsel? 4?
Pardon? 4 minutes.
You may have your 4 minutes.
This case arises in this appeal because a dispute in the law between, on the one hand, this court in its ruling in Dunn versus Eichhoff and the second and third departments which have followed that ruling in their decisions.
Yes, counsel, let me ask you this question. If there's a violation of the physical office requirement and that can be cured by bringing in local counsel after the violation is discovered, what's the effect of the statute? Are we nullifying the statute if we agreed with you?
I think the effect of the statute was directed toward the attorney and not toward the client. So in my judgment, what should have gone in is if there's a complaint against the attorney, that should be brought as contemplated, excuse me.
That's okay.
Under the judiciary law. Remember, this is brought under the judiciary law and not under the civil practice law and rules. And as to the civil practice law and rules, 3211 and the one motion rule apply. The defendant could have brought included in its initial motion to dismiss an objection.
But that presumes knowledge at that time.
Yes, and they had that. Clearly by their own admission in their own documents, which they brought, they concealed that they had hired an investigator to investigate the office initially within a month of receiving.
So the rationale for not calling it a nullity would be this disincentivizes gamesmanship?
Absolutely.
Well, should a court have some discretion to decide whether to allow the violation to be cured or to nullify, depending upon the circumstances? Let's say the circumstances weren't such as they are here.
And let me bring an exact similar example, which is the corporations. If you remember, corporations are required to be represented in court by an attorney. And it has happened not infrequently that corporations, not knowing any better, have filed suit on their own behalf. And typically what happens is the judge, when that's brought to the judge's attention, stays the matter and says, go get an attorney, and you have 30 days or 60 days to have an attorney who's an admitted attorney in New York represent you, and then we'll proceed. If you don't do it in that time period, you're out.
So that's an alternative. That's somewhere in between nullify, right?
Correct.
Well, that's really the opportunity to cure that you're looking for. So
that's right.
I guess my question is, might there be circumstances under which it would not be an abuse of discretion, or if there was discretion, should there be discretion on the part of a judge under appropriate circumstances to dismiss the action and let it be rebrought?
I don't see why there wouldn't be simply a stay granted, permission
Under
granted.
any circumstances.
Yeah, I think
Well, what if there was evidence that the lawyer and the client knew, all right? So, you didn't have the situation where, you're punishing the client for something that he may not or she may not have known about, or if it's a corporation, it may not have known about the lawyer's status.
Then I think the appropriate thing would be referral and sanctions.
And the client doesn't bear any consequence there, even though the client knew.
Sanctions, make them pay the cost. That's what you do in other circumstances.
Cost of what, though?
Pardon?
The cost of what? The motion
The cost of whatever
that the other side brought?
The motion is and whatever inconvenience caused to the court.
You mean like the cost of bringing the motion to identify yourself?
Yes.
So that kind of.
Yes.
Let me ask this: if the rule was modified to a discretionary rule, or if we adopted the second department's approach as opposed to the first department's approach, would the rule need to be different in civil and criminal cases? In one, you have a right to counsel problem, in another you don't. Would there be any reason to distinguish between the two?
I don't do criminal law, so.
The reason I ask is we're in the Court of Appeals, so I like to think of the policy implications and how this would affect this problem in another setting.
I'm uncomfortable answering that because I don't ever handle criminal cases.
Okay, how about this? Have you corrected the error? I noticed there was a
Yes.
different address. You have corrected it.
Yes. I've corrected it, and we also brought in the plaintiff's longstanding counsel who had obtained the original judgment in the very court, same court. To be very blunt, we were operating together all the time anyway.
So in the bottom line, though, what this really goes to is whether this is jurisdictional. And for you to prevail, we would have to find that this is not jurisdictional. And why is that the case?
In Dunn versus Eichhoff, where the issue arose in which the attorney wasn't even admitted to practice in New York, this court said that even though he wasn't admitted, whatever the decision was of the lower court, which had obviously decided against his client, stood.
But is
and
there
it implicitly was saying that you had jurisdiction.
You're not really answering my question.
I don't think this is a jurisdictional issue.
But isn't Dunn, and I think they did in their papers, your adversary, distinguishable on the facts there, where they were affirmatively using the fact that they had a lawyer who was not admitted after they waited to see how the verdict would turn out? So is there a difference in our application of the rule depending on the context?
I don't see that, and again, because I don't see it being jurisdictional. If it were jurisdictional, Dunn versus Eichhoff would have had to come out a different way.
Could you look at Dunn as a waiver?
Yes.
Right, the party waived
Yes.
it. So
If
if it was
that's
jurisdictional, they waived it because they were using it strategically. But here, that's not the case.
In this
So how is
case-
there not a waiver?
In this case, at the very outset of this proceeding, Cheyne had waived subject matter and personal jurisdiction, any objection to it. So if that's the case, there was already a waiver here.
I think the point was the client's waiver, given the client's conduct in Dunn. I may have misunderstood, but I understood that was Judge Garcia's question.
I understood that case to be different in that what they were saying was no do-over, no gamesmanship.
I think in terms of the waiver, I mean, the question is what client's not going to waive?
I
Unless
didn't.
you're going to get a dismissal without prejudice, you'd always waive because you want the proceeding to continue. Or am I misunderstanding where you're going with this?
And keep in mind what the underlying issue in here with the gamesmanship, which is also one of cost. Remember, there were 2 years of litigation in this case. Interrogatories were answered. And notices to admit were answered.
Counsel, let me ask you, if we disagree with your position,
Yeah.
does that mean every case you've appealed in is now nullified?
That's a part of the reason why we appealed rather than refiling. We have already taken 4 EBTs abroad under the Hague Convention with the court's order after these people knew whatever they knew about it. You figure Hague Convention litigation abroad, taking a deposition abroad, to be very blunt, it's about $25,000 a day. On top of which, I don't know that I can go back to a London court and say, you know, the court in New York said this was no good. I don't think the court in London is going to let us take the depositions over again.
Can I ask, Judge, just one
Yes,
more question?
please.
The second issue, on your motion for leave, were you just appealing the 470 issue, or were you also appealing the New York/Cayman Island legal issue?
I was, on the notice of appeal, I was strictly setting the grounds to get us up here. I did not view that as a waiver of our grounds to appeal the other issue as well.
But are you familiar with the Quain decision?
Yes, I am, and that was...
So why doesn't that apply to how you worded your application for
Because
leave?
Quain specifically dealt with the expedited appeal under, as I remember, 400, 500, whatever, 21.
Well, I'm not sure
11.
about that, because I think the section numbers may have changed, and that when Quain came out, it was not applicable just to SSMs.
But to answer, as I read the commentaries in the law, it was that once the appeal gets up here, it brings up everything.
Okay, thank you, counsel. Counsel?
Good afternoon. May it please the court, Shema Hussein of Wilkie Farr and Gallagher on behalf of the Cheney defendants.
So why isn't a sanction sufficient?
Well, Your Honor, it may be that the court decides that sanctions are a sufficient deterrent in order to make sure that Section 470 is effective and actually serves its purpose. But the question that Arrowhead has brought before this court and the ruling that Arrowhead asked this court to find is that, in fact, the cure is sufficient, that the later addition of co-counsel that does, in fact, have a proper New York office cured the violation in this particular instance, and
But why
therefore-
not? Why doesn't it cure it? I mean, he's this attorney who's admitted in New York. So what's the harm?
Well, as this court has said, if a later cure is permitted to retroactively fix all of the prior actions that were taken while the attorney was in violation, well, then Section 470 effectively becomes meaningless.
Well, you know, and Dunn, look, if a disbarred attorney, as far as I can tell, you haven't claimed that he is not in good standing. He's admitted in New York, he's otherwise in good standing. And if in Dunn, a disbarred attorney's presence doesn't nullify the proceedings, I'm very hard-pressed to see, unless you could establish prejudice, why this proceeding should now be nullified.
We submit that the facts
When
of
they can just
Dunn-
bring in, as they have, someone who has a New York office.
Your Honor, that's a fair point, but the facts of Dunn are completely distinguishable. In Dunn, it was the plaintiffs themselves who sought to move for a mistrial based on the fact that their own attorney was disbarred.
But that may be, but the question is whether it must be nullified. And one of my questions about that is what does it serve to nullify it? And in fact, isn't it a terrible waste of judicial resources, particularly in a case like this, where we've heard all about all the discovery and multinational and everything else? And, aren't there other remedies, disciplinary proceedings, sanctions against either just the attorney or both the client and the attorney, depending on the circumstances, that will suffice to enforce the purpose of the rule? Why nullify? I don't understand what the purpose is.
Nullification, Your Honor, is necessary because Section 470 is a requirement for a non-resident attorney to practice in New York. And so, in other words, if a non-resident attorney violates Section 470, that attorney does not have the authority of the state of New York to practice in this state. And so a complaint filed by that
How
attorney...
does a disbarred attorney have any more authority? I find that argument that you made before a bit absurd to me. You're arguing that when the client knows and acts badly, it's not nullified. It's a good proceeding. It will have effect moving forward. But when the client, as far as I can tell, you haven't argued here, the client acted badly or had knowledge that there was a violation of the rule, seems to be an innocent in this, they have to suffer the consequences of a completely nullified proceeding and the costs associated with that.
Well, and Dunn, to allow the client to nullify the proceedings would effectively be to reward the client for its gamesmanship, to reward the client for waiting until the jury verdict came back
That's
and
a
seeing what it was.
difficult argument, it seems to me, because nullity then is a perspective. So if it's in this context, it's a nullity. If it's in this other context, it's not a nullity. And isn't that a difficult rule then to apply, rather than a rule that says, if you can show prejudice, you get some type of result, but it's not automatically nullified?
Relying on a showing of prejudice would, as I've stated, effectively make Section 470 meaningless.
But then you're arguing, I think you're arguing, okay, you need a penalty to enforce 470 to ensure compliance, a deterrent, let's say. But isn't that sanctions? Isn't that disciplinary action? What attorney would risk disciplinary action? Isn't that sanction, that penalty enough?
The court may find that sanctions are also a proper remedy, but Section 470 was intended, as the Second Circuit stated, to ensure that non-resident attorneys establish a presence in the state that is akin to that of resident attorneys.
So if you are saying that it depends on the circumstances, then in answer to a question that I asked your adversary, are you really saying that it should be up to the discretion of the court to decide whether to nullify or to impose some other sanction, or to simply allow a cure without any sanction?
We submit, Your Honor, even if the court is to decide that it should have discretion to decide whether it is a nullity or whether the case can move forward with new counsel or a New York office.
That's not what happened here. Here the court said it was constrained, it was required under the appellate division precedent to do that.
That's right. And the facts of this case would not really make it the proper case, even if the court had discretion to turn a blind eye and decide that the prior action should not be nullified. We're dealing with an attorney who, by his own admission, has been licensed to practice in New York for over 30 years. He's familiar with the rules, and he's well aware of Section 470.
But why punish the client here?
Well, there are reasons why the legislature decided to enact Section 470, and
Yes, but the legislature didn't say that it rendered it a nullity.
That's correct. That's not what the legislator said. That's how it's been interpreted by the First
Speaking
Department
of familiarity with the rules, are you familiar at all with CPLR 321C, and does it have any application here?
I'm not familiar with CPLR.
Okay, it basically says, and we have a decision interpreting it, it's called Murray versus Coven-Kraus at 15 New York 3rd, 384, if I'm reading correctly. The rule basically says if an attorney is suspended or disbarred or otherwise disabled, then there's an automatic stay of the proceedings, and that runs from 30 days from the point where the adversary sends notice. So doesn't that suggest that the remedy for a lawyer who is not, for whatever reason, able to represent a client is not throwing the action out, but is holding everything in place until a new lawyer comes in?
That would not provide a sufficient deterrent, though, for non-resident attorneys at the outset to make sure that they are in compliance with the rule.
But I think you already told me that the sanctions might be a sufficient deterrent.
The court might decide that sanctions might be a sufficient deterrent, but that's not the question that Arrowhead has posed. The Arrowhead is asking this court to decide in this matter that a later cure makes everything fixed, that you can look back retroactively and decide that no matter what the violation
But I think that's sort of what 321C says,
that
it provides for a later cure by substitution, and it stays everything until the cure can take place.
We'd submit that that still undermines the purpose of Section 470.
Well, then the legislature's undermined it.
Well,
I mean, maybe, is it that 321C presumes that you start out with an attorney who is, in fact, authorized to do whatever he or she is, and then 321C kicks in when they become disabled or suspended or whatever, or perhaps fails to pay their registration fee under 486-A, whatever the problem may be.
That's exactly right, Your Honor. We're dealing with a situation in which, from the outset, the attorney is not in compliance with Section 470.
Right.
And
but that gets, so if you're talking about what's at the outset, what you're really talking about is whether or not this is jurisdictional. And so I asked you the same question that I asked your adversary. Why is this jurisdictional?
It is jurisdictional because there are requirements to practice law in New York. And if an attorney is not compliant with all of those requirements, he does not have the authority to practice. So a complaint.
So if it is jurisdictional, why isn't your adversary correct that there's been a waiver here of both subject matter and personal jurisdiction issues?
The waiver dealt only with regard to those issues, and it was later, at a subsequent point, that the Cheyne defendants became aware that, in fact, Mr. Golden was practicing without a New York office.
So let me just clarify the parameters of your reading of the statute and your rule. So if the lawyer was in compliance with 470 when the papers are initially filed and loses the lease, let's say a year into the litigation, what happens? Your rule.
That's a different situation.
I'm asking you under your rule.
In that instance, there could be appropriate sanctions or remedies, but it would not nullify the entire action.
Why not?
Because at the time that the complaint was filed, it would have been filed by an attorney.
What about during that period when they lost their lease?
Well, during the period that they lost their lease, that would depend on sort of the facts of the instances of the case and what happened in that
So
instance.
you concede there might be parts of the lawsuit or the entire lawsuit that are not nullified, even though the lawyer is not in compliance with 470.
Absolutely, but those are not the facts of this case.
So how is it then jurisdictional?
Well, it's not a jurisdictional issue. It's an issue of as to whether the lawyer has the authority to practice and whether the lawyer had the authority to file the papers. It deals with the matter and the ability
And
of this
continue to
court
file
hear it.
papers, no?
And to
In my
continue to file
example, the
papers.
lease lapses, doesn't get another address in New York, but continues to file papers. Let's say they do it for another 2 years.
That's correct, but that's still an
But
instance
you say
in
that's
which-
not nullification.
Well, that would not implicate
Won't
the
nullify.
commencement of the case. That would implicate perhaps things that happened subsequent to the commencement, but here we're dealing with the commencement of the
Well,
action.
does the rule on commencing an action say that the summons and complaint must be served by a lawyer, or that it must be represented at that point? What commences a case?
It may very well be that you decide to proceed pro se or that you're not represented by an attorney, but if you are represented by an attorney, that attorney has to have the authority to practice in this state.
What if
And
you're represented by more than one counsel and only one of them doesn't have the office?
That would be
As
fine.
you argue in this case now that they've had Arrowhead.
That would be fine. If they had had their New York counsel, the Wilmuth firm, from the beginning, that would have been fine, and the Wilmuth firm could have filed the complaint and signed the complaint, and that would not have been a violation under Section
As long
470.
as some attorney.
I think that's right. As long as there is an attorney that is
Do
practicing.
they have to be the one that signs all the papers?
Yes. In order for the papers to be valid, it has to be an attorney with the authority to practice.
Quickly, your red light is on. If the chief permits me, you just want to take a moment to address the second point about the
Yes.
remaining issues?
Thank you, Your Honor. As the court has already recognized, Mr. Golden, when Arrowhead filed its motion for leave to appeal, it did in fact identify only a single issue, the dismissal pursuant to Section 470. Under the Quain v. Bozzetto construction case, it is clear that the appeal cannot later be expanded to add additional issues, here specifically the dismissal of the Cheyne general partner. And as the court explained in the Quain case, that's because it would be unfair. It would be unfair for the other parties to not have notice of all of the legal issues that are being presented for appeal. Had they been aware of the other additional issues, the other parties may have decided to cross-appeal or take some other action. We think that the Quain case is controlling precedent. The circumstances are exactly the same as here, and for that reason, we ask the court to strike Question 2 and Part 2 of the appeal brief.
Thank you, counsel.
Thank you
Counsel?
very much.
Yes.
So, if I may, can you just articulate for me how you would word the rule, and then secondly, what's the rationale you would give for the rule?
Which rule?
The rule that this is a curable defect.
I would simply say exactly what you just said. This is a
So the
curable.
rule,
This is, when an attorney is an admitted New York attorney who for some reason does not have a sufficient New York office. The issue isn't that I didn't have a New York office. The issue is only the sufficiency of the New York office, which I could have contested if there had been a sanctions hearing. Much of the evidence in here came up on a rebuttal.
I thought the rationale for your rule was that this is not jurisdictional, and at least under these circumstances, the client should not be punished.
Absolutely. Absolutely. So to answer your question, where there is an admitted New York attorney, and for some reason his law office in New York is held to be insufficient, that the proper remedy of the court below is to stay the proceedings for a given period of time until a proper New York attorney with sufficient New York office can be brought in to handle the matter. And if that doesn't happen within a specific period of time, then dismiss without prejudice.
Thank you, counsel.